Usually on Mondays. We'll see how it goes.
Usually 3 and then anything on the year.
They left or?
Yeah, one went down. One of their officers.
Oh, that's nice. Good. I'm going 5 and 2, so I want you to start it. So it's nice to come in on Monday. Be part.
Yeah, definitely. She'll make present on Monday.
That's good. Or a coffee shop. Oh, that's.
I'm telling you, that's why I was doing. Yeah, a lot of people working on it. Okay, so.
Yeah.
Great. Good morning, Mr. Shepherd. We're going to get started, okay?
Okay, thank you.
All right. So good morning, I'm Parole Officer Trisella, and I'm the hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Robert Shepherd, inmate number 266562. Today is Monday, June 1st, 2026, and this hearing is being conducted via video at the Board of Pardons and Parole Central Office in Hartford Correctional Center. Can you please state your full name and DOC inmate number for the record?
Robert Shepherd, 266562.
Thank you. So this is a public hearing and public access to this hearing is available via video live stream. Present this morning is your attorney. Can you please identify yourself for the record?
Yes, thank you. Attorney Sonia Jones, Public Defender's Office on behalf of Mr. Shepherd.
Thank you. So this is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of facts as to each of the charges against you. The state, not you, has a responsibility to prove the allegations by preponderance of evidence, and that is a better weightier evidence must establish that, more probably than not, the allegation is true. If I do not find that there is preponderance of evidence to support a violation of one or more of the conditions of your parole, I'll reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked, and if I recommend revocation, I'll make a recommendation as to an appropriate sanction. My recommendation will then be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. Mr. Shepherd, can you please raise your right hand? Do you solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
I do.
Thank you. So we're going to go over the procedure for today's hearing. First, I'm going to read you your rights. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. We'll then review and identify the exhibits that have been filed for the record. The state is not present at today's proceedings. However, you will have an opportunity to present any relevant testimony and any relevant documents. After considering all the evidence presented, I will announce my findings. And if I find that you have violated one or more of the conditions of your parole, you'll have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No, I don't.
You do have important rights at today's hearing, and we're going to review them now. You have the right to be represented by an attorney, and counsel is here present for you. You also have the right to receive a written notice of charges of violation. Did you receive that written notice?
Yes, I did.
Good. You also have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. You understand these rights, and are you ready to go forward?
Yes, I do.
We'll now review the charges that the state, your parole officer, is bringing against you, and the information underlying each charge. So on charge number 1, the condition of program participation, the charging officer reported that on 12/1/25, you were instructed to conduct a phone screening for inpatient substance abuse treatment at Foundation due to admitting to using cocaine on 11/25/25 and 11/28/25. You failed to follow the instructions as given. Instead, you walked out of the Chase Center halfway house without authorization and ceased all contact with parole in the halfway house. You violated your special parole conditions. I will agree to participate in programs as determined by my parole officer. On charge number 2, the condition of absconder, the charging officer reported that on 12/1/25 at approximately 1:15 p.m., you were escorted to your case manager's office to conduct a phone screening for inpatient substance abuse treatment with the App Foundation. Shortly after entering the case manager's office, you walked out and stated that you were leaving to obtain your methadone dose. You failed to return to the Chase Center halfway house, your only parole approved residence located at 21 Cliff Street in Waterbury. Staff contacted Waterbury Hospital and St. Mary's Hospital to no avail. Your case manager also contacted Connecticut Counseling where you obtained your methadone dosing and they confirmed you had not been there as well. Attempts to call and text you by your cell phone were unanswered, and attempts to physically locate you in Waterbury were unsuccessful. You violated your conditions of special parole. I live in a residence approved by my parole officer. On charge number 3, the condition of drugs, the charging officer reported that on 11/26/25, you signed a voluntary admission form admitting you used cocaine on 11/25/26. On 11/28/25, you signed a voluntary admission form admitting you used cocaine on 11/28/25. You violated your conditions of parole that I will not use or have in my possession or control any illegal drugs, narcotics, or drug paraphernalia. On charge number 4, the condition of halfway house placement, the charging officer reported that on 11/28/25 at 7:15 a.m., you sent out of the Chase Center halfway house to obtain your methadone dose at Connecticut Counseling Center. You were given take-home bottles of methadone due to the office being closed following the Thanksgiving holiday. Staff attempted to contact you and to instruct you to return to the halfway house. However, you did not answer and your voicemail was not set up to receive messages. Local hospitals were contacted with no avail. Staff contacted you in person. Staff conducted an in-person spot check at Connecticut Counseling, and you were not there. The PO called and sent a text message instructing you to call me now with return to the halfway house. You did not answer or call this PO grant. You returned to the halfway house on 11/30/25 at approximately 4:46 a.m. You were unaccounted for in the community for 45 hours and 31 minutes. You rendered a UA and provided a BAC. The BAC was 0.00 and the UA was positive for cocaine, and you signed a voluntary admission form admitting to using cocaine. On 12/1/25 at approximately 1:15 p.m., you were escorted to your case manager's office to conduct a phone screen for inpatient substance abuse treatment at App Foundation. Shortly after entering the case manager's office, you walked out of the office and stated you were leaving to obtain your methadone dose. The PO was on the phone with PD Rodriguez and asked to speak to you. You continued to walk towards the exit and left the facility without authorization. You stated, I'm going to get my methadone. You failed to return to the Chase Center halfway house. You're only a parole-approved residence located at 21 Cliff Street in Waterbury. Staff contacted Waterbury Hospital, St. Mary's Hospital, and local PD to no avail. Your case manager also contacted Connecticut Counseling where you obtained your methadone dosing, which they were confirmed you had not been there as well. Attempts to call and text you on your cell phone were unsuccessful, and attempts to physically locate you in Waterbury area were unsuccessful. You violated your halfway house agreement. I will not leave physical confines of the halfway house unless authorized by parole staff or program staff or parole. The state did file the following exhibits for the case that have been identified as Exhibit A, the remains actual custody, Exhibit B, the parole violation report, Exhibit C, the signed parole conditions, Exhibit D, the halfway house agreement, Exhibit E, the residential disciplinary report dated 11/26/25, Exhibit F, the voluntary admission of positive test result dated 11/26/25, Exhibit G, the incident report dated 11/28/25, Exhibit H, the voluntary admission of positive test results dated 11/28/25, Exhibit I, the residential substance abuse referral, Exhibit J, the incident report dated 12/1/25, Exhibit K, the residential substance use service for DOC referral pre-screen, Exhibit L, the email from CC Bordolato regarding the app phone screening, Exhibit M, the email from PO Grant to chief staff reading halfway app phone screening, Exhibit N, the revocation hearing summaries, Exhibit O, the notice of parole violation, and Exhibit P, the notice of parole rights. I do want to note on the record that Exhibit I was not received, so that one is not going to be admitted into evidence for today's hearing. And in addition, the state has filed an addendum to the parole violation report on April 15, 2026 that reads that on January 6, 2026, the Board of Parole issued a warrant based on the report declaring Shepard an absconder from special parole supervision. And then on 4/13/26, Shepard was apprehended by the Parole Fugitive Investigation Unit subsequent to a short foot pursuit. A remand to custody order was lodged at Hartford Correctional Center. So counsel, to confirm, you and your client did receive the notice of parole violation, the parole violation report, and all the other documents identified for today.
Yes.
And I did receive Exhibit 1 from the defense, which is the list of parole accomplishments and future plans or parole reinstatement. Counsel, do you need time to submit any other documents?
No.
I do not have any witnesses. So at this time, it is the defense's opportunity to present evidence and speak to any of the evidence submitted. So counsel?
Yes, thank you. In regards to charge one, program participation, we would submit there's insufficient evidence to support a finding. As Exhibit L is a document that indicates that my client can call into the App Foundation after 12 p.m. on December 1st is when the email was sent of 2025. But there's no evidence submitted to suggest that he did not make that phone call at any point after that time. So based on that, we would submit there's insufficient evidence to support a finding on that charge. In regards to the remaining charges, just a general statement. My client does have two children who are 13 years old. They're twins. They were in the custody of DCF and had just been returned to family members. The reason why he left was to go see his children who he hadn't been able to see in a long time. And certainly that wasn't the best decision to make, but it is the decision that he did make. Once he was there and spending time, he then got to a point where he felt as though he could no longer return because he would be likely going to jail since he left, and then obviously made the decision not to return and escalated things. So just to cover the reasons why, I know it's not a defense, and nothing further as to the charges.
Thank you. Just take a moment and announce my things. So on charge number one, Mr. Shepherd, I am making a finding that you violated the condition of program participation based on the evidence presented in states exhibits B, C, and J. On charge number two, I'm finding you violated the condition of absconder based on the evidence presented in states exhibits B, C, J. On charge number three, I'm also finding that you violated the condition of drugs based on the evidence presented in states exhibits B, C, G, F, G, and H. On charge number four, the condition of halfway house placement, I'm also finding you violated that condition based on the evidence presented in states exhibits B, C, D, G, and J. So that does conclude the fact-finding portion of today's hearing. Before I make my recommendation, I'll have an opportunity to speak to your background and history. The purpose of this part of the revocation hearing is to help determine what outcome I recommend. So counsel?
Yes, thank you. My client is 49 years of age. He's single. He does have 7 children, 2 of whom are minors, 13 years old. He does receive his primary support from his mother, who's located in Florida, as well as his oldest daughter, who's located in Manchester. He does have a high school diploma from Fermi High School in Enfield. He does live with both mental health as well as substance abuse issues. I do understand he was in the community for a short period of time, having utilized the Community Solutions Halfway House program. And again, unfortunately, he did make that decision to leave to go see his children. He hadn't seen them in some time. And then again, he got to the point where he was fearful if he returned that he would then be returned to custody. And so he made the decision not to. So unfortunately, he did not handle things appropriately. He understands that. He admits to that. By way of his employment history, he reports being a roofer for the past 19 years. He previously ran his own business. He reports holding a forklift certification that he just recently renewed. He also worked full-time for a short period of time at Taylor Rental in Manchester, also at Concrete Support Systems in Windsor Locks, and then at Trader Joe Warehouse in Bloomfield. He was receiving medication-assisted treatment in the form of methadone from Connecticut Counseling Center in Waterbury, and previously had success at completing the App Foundation residential treatment program. During the time that he's now been within the Department of Corrections, he indicates that he has begun working in the Tier 1 program. He also receives medication-assisted treatment and attends and participates in group therapy. For housing, if he's re-paroled, he's asking to be placed in a halfway house in either the Hartford area or the New Haven area. He is open to all employment opportunities. He specifically would like, in terms of treatment, to work with Community Partners in Actions located in Hartford, to get back involved with substance abuse treatment as well as counseling. His parole is scheduled to end, I believe, December 6th of 2027. He certainly does not have anywhere to go when his parole ends. We would be asking that he be re-paroled at some point prior to that date, just so that he can utilize services to get back on his feet, so he's not in a situation where he is homeless. Mr. Shepherd, is there anything that you want to add?
I just want to add a little bit to the fact that you mentioned I do have a drug problem and a lot of mental health issues that I've been dealing with for some years now. And in the past 6 years, it escalated due to traumatic incidences that happened between my kids, as you said. And I'm actively and currently working on that. It's a very difficult situation. I do admit that, and I'm doing the best I can. I'm working as hard as I can. I'm currently signed up for. I'm actively doing tier 1. I'm signed up for tier 2. I'm signed up for a fatherhood program, and I receive mental health services and counseling on a weekly basis now. So I'm actively trying to help myself and do what I can, and hopefully that gets better in the future. And I am currently on mental health medication as well. So I'm trying to figure out the best way to help this situation and make me make the right decisions in the future.
Thank you.
Thank you, Mr. Shepherd. I appreciate your statement. I'm just going to take a moment, then I'll announce my recommendation. I do want to just note on the record, Mr. Shepherd, this is your 5th violation on special parole, 2nd time absconding, and you were only on supervision for approximately 12 days between your re-release and when you left the halfway house. During that time, you did test positive twice for drugs, and you were unaccountable for approximately 4.5 months. Parole and Community Services has requested that you remain incarcerated through the end of your special parole. So I am going to recommend, Mr. Shepherd, that your parole be revoked and that you have no new re-parole date, which is an approximate 20-month period of confinement as a sanction. In the event the board decides to lessen my recommendation, I'm going to recommend the conditions of no consumption of alcoholic beverages, no contact with co-defendant Teresi O'Hara, a general no contact with Home Depot in West Hartford, mental health treatment, and halfway house placement. So that's approximately a 20-month sanction, Mr. Shepherd. So what's going to happen is my recommendation is going to go to the board on June 11th. On that day, the board can do 2 things. They can adopt the recommendation if they want to, or if they want to, or they can lower it to any date between June 11th of this year and your end of special parole. So they can choose any date in between, whatever they want to do. Okay.
All right.
So on that date, you'll be, we'll send you paperwork about a week or so after with their final decision of what they decided on that date of the board review. Okay.
All right.
Good, counsel.
I'm sorry, you said June 11th was the board review?
Yes.
Okay, thank you. Mr. Shepherd, if you want to contact me after June 11th, I can let you know what the board decided, okay?
Okay, I think it would be a smart decision to put me in a halfway house a little bit earlier than the release. I mean, going home to complete discharge with nowhere to go is kind of reckless.
Well, I'll make note of your statements and comments to the board. Let them know what you're asking for. And like I said, it's their decision on that day.
Yeah.
They can pick any day they want to. Just want to make notes of it. Okay, 1 second. Great. Thank you, Mr. Shepherd, and good luck to you. Okay.
Thank you.
Thank you.
Thank you. This concludes the revocation hearing for Robert Shepherd, inmate number 266562. Hello.
Good morning.
Good morning. I think I only have one with you today, correct?
Yes,
Yes, Mr. Mendez.
Running.
Yeah, absolutely. Thank you.
Come on in, Mandy.
Thank you. All right, let me go here. Don't come over to that.
Good morning, Mr. Mendez. How are you?
Well,
I'm just waiting for your attorney to show up and we have to wait for it to be 9:30. So it's 9:25 right now. So we'll get started in 5 minutes, okay?
All right, yeah.
Yeah, I can do that. We're going to Jeff Sharp.
Sorry, that's okay. All right, so
Excuse
good
me?
morning. Yeah.
Good morning.
You're good?
I mean, yeah,
You're good? Okay. All right, so good morning. I'm Parole Officer Trisell, and I'm a hearing examiner for the Board of Pardons and Parole. This is a revocation hearing concerning Antonio Mendez, inmate number 267191. Today is Monday, June 1st, 2026, and this hearing is being conducted via video at the Board of Pardons and Parole Central Office in Osborne Correctional Institution. Can you please state your full name and DOC inmate number for the record?
Luis Antonio Mendez, 267191.
Thank you. So this is a public hearing and public access to this hearing is available via video live stream. Present this morning is your attorney. Can you please identify yourself for the record?
Yes, Hannah Jean on behalf of Mr. Mendez. Good morning.
So this is a revocation hearing to determine whether you have violated the conditions of your release. I'll review and make findings of facts as each of the charges against you. The state, not you, has a responsibility to prove the allegations by a preponderance of evidence, and that is the better weightier evidence must establish that more probably than not the allegation is true. If I do not find that there's preponderance of evidence to support a violation of one or more of the conditions of your parole, I'll reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I'll consider whether or not your parole should be revoked. And if I recommend a revocation, I'll make a recommendation as to an appropriate sanction. The recommendation will then be given to a panel for a final decision. And if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. Mr. Mendez, can you please raise your right hand? Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury?
Yes, I do.
Thank you. So we're going to go over the procedure for today's hearing. So first, I'm going to read you your rights. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. We'll then review and identify the exhibits that have been filed for the record. The state is not present at today's proceedings. However, you'll have an opportunity to address the issue. Sorry, that's the wrong thing. You'll have an opportunity to present any relevant testimony and any relevant documents. After considering all the evidence presented, I will announce my findings. And if I find that you violated one or more of the conditions of your parole, you will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No.
Okay, so you do have important rights, and we're going to review them now. You have the right to be represented by an attorney, and counsel is here present for you. You also have the right to receive the written notice of charges of violation. Did you receive that written notice?
Yes.
Do you have the right to review the evidence against you before this hearing? You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes.
We'll now review the charge that the state, your parole officer, is bringing against you and the information underlying that charge. So charge number one, the condition of obedience to the law. The charging officer reported that on 1/14/26, you were observed in the vehicle, engaged in hurried conversations, and appeared to exchange what seemed to be hand-to-hand drug transactions. You, during the investigation, you were found to be in possession of one small blue pill stamped with an M, which was discovered inside your jacket pocket. The pill was identified as an opioid. On 1/14/26, you were arrested by Hartford Police Department. You were charged with sale of narcotics, possession of controlled substance, first offense ×2, and possession with intent to sell, dispense narcotics. The evidence submitted by the state was already identified at the preliminary hearing, and that all remains the same. The state did submit an addendum to the parole violation report on April 29th that states that Mr. Mendez appeared in court on 4/22/26 and received an unconditional discharge for the charge of possession of the controlled substance, first offense, and all three other charges against him were nullied. Counsel, to review, you and your client did receive a notice of parole violation, the parole violation for, and all the other documents identified for today.
Yes, we have.
Perfect. I did receive an exhibit from the defense. I have exhibit 1, a list of parole accomplishments and future plans for parole reinstatement. Counsel, do you need time to submit any other documents?
No, we do not. Thank you.
And there are no witnesses. So at this time, it's a defense's opportunity to present evidence and to speak to any of the evidence submitted. So counsel?
Yes, thank you. As to the charges, I would just note the addendum is accurate. My client just received the one unconditional discharge on one count of possession. Everything else was nollied. I would like to note and argue that there should be a no finding for the sale charges here. Again, those charges were nollied, and I would argue that the alleged behaviors here don't meet the elements of that charge, and the facts don't support those charges for my client. My client is accused in this specific case of having one singular Percocet pill in his possession during the traffic stop, which he owned up to and accepted the UCE for. He has struggled in the past with drug dependence, and I think this is more accurately, portrayed as a situation of relapse rather than sale. Another individual in the vehicle is accused of having a larger quantity of drugs on him, which matched the drugs that were allegedly sold to the other individual. But at no point was my client observed to be in possession of those drugs. And additionally, the facts in the report do not suggest that my client at any point was engaged in hand-to-hand transactions. In fact, the report alleges that it was the female operator who was being approached. So based on all of that, I would argue that for the other charges, there should be a no finding. And lastly, I will just note my client was forthcoming with parole about his arrest. He did disclose to them that that had happened. So I do think that deserves some consideration. Thank you.
Thank you. Okay, Mr. Mendez, so on charge number 1, I am gonna make a no finding for the charges of sale of narcotic substances and didn't write the other one down. The possession with intent to sell. As council stated, the elements are not met by the evidence that has been submitted by the state to meet the preponderance standard. I am gonna make a finding on both counts of the possession of the controlled substance based on your conviction of that, one count of the possession of the controlled substance on 422 when you receive the sentence of unconditional discharge. In addition, the evidence in support of that charge, it states exhibits C, E, F, and G. So it does conclude the fact-finding portion of this hearing. Before I make my recommendation, you'll have a chance to speak to your background and history. The purpose of this part of the revocation hearing is to help determine what outcome I recommend. So counsel?
Yes, thank you. My client, Mr. Mendez, is 44 years old, born and raised in Hartford. He does have a strong support system, including his mom, his grandmother, 2 sisters, uncles, nieces, nephews, amongst other family members. My client also reports that he does have additional support in the community from his treatment team through CRT. He also has 2 adult children and 2 grandkids. Most recently, upon release from Osborne to special parole in December of 2025, my client was sponsored by his nephew in Hartford. Most recently, he was actively searching for work. Previously, while in supervision, my client successfully completed outpatient services through CRT and also did MAT treatment there. Since being on parole, he was on a minimum contact schedule with a good regularity. Since being remanded to custody, my client has been doing the MAT program for Suboxone. He's been doing as well individual therapy once monthly and groups twice per week or twice per month. He's had no DRs during this period of incarceration. Upon reinstatement of his special parole, he would like to return to being sponsored by his nephew. He hopes to obtain his GED to further his job prospects in the future. He's open to any sort of job opportunities in the community and is specifically interested in a warehouse or manual labor position, and is also interested in obtaining a forklift licensure that he could then utilize. He's open to any sort of treatment being recommended, including successfully completing TB programming and reestablishing IOP through CRT. I am asking you to consider a sanction not to exceed 4.5 months for Mr. Mendez. He has been incarcerated since January of this year. And as we noted, he did notify parole about his arrest and the more serious charges were nollied. Again, I think this was more of a situation where my client was struggling with relapse as opposed to this being a sales situation. Mr. Mendez, is there anything I left out that you want to say at this time?
No.
Thank you.
Thank you. All right, so I do just want to note that this, Mr. Mendez, is your second violation on special parole. Both have been criminal violations for drugs. You were only on supervision for approximately 1.5 months between your re-release and remand to custody. Parole and Community Services has asked for a 6-month sanction after disposition. So with that, I'm going to recommend that Mr. Mendez, your parole be revoked and that you serve an approximate 6-month period of confinement as a sanction. And that's with the re-parole date of July 29th, 2026. I'm going to recommend the following conditions: no consumption of alcoholic beverages, behavioral management program for domestic violence, no contact with victim AB. And I'll put the sponsor information in the system. So what happens next, Mr. Mendez, is that my recommendation is going to go to the board on June 11th. On that date, the board can do 3 things. They can adopt that recommendation if they choose to do so. they can lessen it if they choose to do so. So any date between June 11th and July 29th. And then if for any reason they would want to see a longer period of confinement as a sanction, they'll ask you to come back for a third hearing to address their questions and concerns before anything longer is imposed. Okay. Do you have any questions?
No, thank you.
This does conclude the revocation hearing for Antonio Mendez and meeting number 267191. Good luck to you, Mr. Mendez.
All right, thank you.
Thank
Thank
you.
you, everyone.
Thanks.
Good morning. Oh, you guys are muted. Bridgeport.
Good morning.
Good morning, Officer Montoya.
Good morning.
Hello.
Yeah, works good. Thank you. Good morning, Mr. Jacques. How are you? How are you?
doing?
Good. So it is 9:56. We have to wait till exactly 10 a.m. to start. So we'll start in about 4 minutes, okay?
Okay.
All right. Same thing, Officer Montoya, 4 minutes.
Thank you.
Thanks. Sorry, it's still 2 more minutes. It's probably the longest 4 minutes ever, but it's almost
fine.
over. Okay.
No worries.
Okay, we're gonna get started. So good morning, I'm Parole Officer Trisell, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning I'm sorry, how do you say your first name?
Escom.
Esholm Jacques, inmate number 314555. Today is Monday, June 1st, 2026, and this hearing is being conducted via video at the Board of Pardons and Parole Central Office and Bridgeport Correctional Center. Can you please state your full name and DOC inmate number for the record?
Escom Jacques, 314555.
Thank you. So this is a public hearing. Public access to this hearing is available via video live stream. Present this morning is your attorney. Can you please identify yourself for the record?
Good morning, Peter Matthews at the Public Defender's Office, and Mr. Jock.
Thanks. And also present this morning is your charging officer. Can you please identify yourself for the record?
Good morning, Catherine Montoya, Parole Officer, Waterbury.
Thank you. So this is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of facts as each of the charges against you. The state, not you, has a responsibility to prove the allegations by preponderance of evidence, and that is the better or weightier evidence must establish that more probably than not the allegation is true. If I do not find that there's preponderance of evidence to support a violation of one or more of the conditions of your parole, I'll reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I'll consider whether or not your parole should be revoked. And if I recommend revocation, I'll make a recommendation as to an appropriate sanction. My recommendation will then be given to a panel for a final decision. And if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oaths. Mr. Jock and Officer Montoya, can you both please raise your right hands? You solemnly swear, solemnly sincerely affirm as the case may be that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury.
I do.
I do.
Thank you. So we're going to go over the procedure for today. So first I'm going to read you your rights. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. We'll then review and identify the exhibits that have been filed for the record. The state will then have an opportunity to present all relevant testimony subject to cross-examination and any relevant documents. After the state is finished, you will have the same opportunity. After considering all the evidence presented, I will announce my findings. And if I find that you have violated one or more of the conditions of your parole, the state will have an opportunity to speak to your background and history. After the state is finished, you will have the same opportunity. Do you have any questions about the purpose or procedure before we begin?
No.
No.
So you have important rights at today's hearing, and we're going to review them now. You have the right to be represented by an attorney, and counsel is here present for you. You also have the right to receive the written notice of charge of the violation. Did you receive that written notice?
Yes.
Perfect. You have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes.
So we'll now review the charges that the state, your parole officer, is bringing against you and the information underlying each charge. So Officer Montoya, can you please review the charges for us, starting with number 1, absconder?
Sure. Give me 1 second, please. Charge 1, absconder. On 2/18/2026, around 2:51 p.m., Jack was released from Franklin County Jail in Jamesport, Pennsylvania. At the time of his release, Jack signed reporting instructions indicating that he is to report to the Waterbury Parole Office upon release, as well as to call his parole officer as soon as he made bail. As of 2/20/2026, subject failed to contact these officers or report as instructed. These officers sent text messages to Jax on 2/19 with negative results. You failed to report to this officer as instructed on 2/18/2026. You failed to contact your parole officer since 2/18/2026. Your whereabouts in the community have been unknown since 2/18/2026. Charge 2, obedience of the law. On 2/13/2026, Pennsylvania State Troopers attempted to conduct a traffic stop. Due to you driving at a high rate of speed, you refused to pull over and ended up crashing into a snowbank. Pennsylvania State Troopers found a small amount of marijuana in a scale. You were driving a vehicle that was not registered, and your vehicle's plate was covered in a manner that prevented law enforcement officers from properly identifying the jurisdiction of your vehicle. You were subsequently arrested and charged with the following charges in Pennsylvania: marijuana, a small amount for personal use, use of possession of drug paraphernalia, registration required, expire after 60 days, non-PA expire or unregistered, obscure plate, obscure on cover or inhibit visibility to plate, obedience to traffic control device, driving at a safe speed, 1-49 maximum speed limit freeways, careless driving, general rules 75-3733, fleeing or attempting to elude officer. On 213, third charge, drugs. On 2/13/2026, Pennsylvania State Troopers attempted to conduct a traffic stop. Due to you driving at a high rate of speed, you refused to pull over and ended up crashing into a snowbank. Pennsylvania State Troopers found a small amount of marijuana in a scale. You were subsequently arrested and charged with Pennsylvania charges: marijuana, small amount for personal use, possession of drug paraphernalia. Charge for travel. On 2/13/2026, Pennsylvania State Troopers initiated a traffic stop. You failed to stop and accelerated the vehicle at a high rate, resulting in you losing control of the vehicle and crashing into a snowbank. Pennsylvania State Troopers call Waterbury District officers and report that you were in the state of Pennsylvania. You did not have permission to leave the state of Connecticut.
Thank you. You've also submitted evidence in support of the charges. Can you please identify the evidence for us?
Sure. Exhibit A, remand to custody order. Exhibit B, parole conditions. Exhibit C, parole violation report. Exhibit D, notice of parole violation. Exhibit E, Commonwealth of Pennsylvania Police Criminal Complaint Report number H1B5BL085B. Exhibit F, Magisterial District Court 39-3-04 Public Court Summary. Exhibit G, Decision Information Summary. Exhibit H, Decision Information Summary. Exhibit I, Revocation Hearing Summary dated 7/31/2024. Exhibit J, Revocation Hearing Summary dated 8/26/2022. Exhibit K, Revocation Hearing Summary 4/20/2021. Exhibit L, Reporting Instructions directing JAX to report JAX 314555 to call report once he is released from custody in Pennsylvania. Exhibit M, photo of business cards with reporting instructions left by JAX residents.
Thank you. You've also submitted an addendum to the parole violation report. Can you please review that for us?
Sure. In reference to the parole violation, the addendum was submitted by Officer Timbro, but I will read it. It wasn't submitted by me.
Okay, all right. Thank you for clarifying that.
In reference to the parole violation report submitted by Pierre Montoya regarding Exxon JAX 314555, the following applies. On 3/5/2026, the Board of Parole issued a warrant based on the report declaring the offender an absconder from special parole supervision. On 3/11/2026, the case was transferred to FIU for investigation. That's Fugitive Investigation Unit. On 2/13/2026, JAX was apprehended by Pennsylvania State Police for marijuana, small amount personal use, count 1. Use, possession of drug paraphernalia, 1 count. Registration required, PA registration expired more than 60 days, non-PA expired or unregistered, 1 count. Obscure license plate, obscure cover or inhibit visibility. Obedience to traffic control device, driving at safe speed. 1-49 maximum speed limit freeways. Careless driving, general rule, 1 count. Fleeing or attempting to elude police officers, felony 3. JAX signed his waiver of extradition on 4/15/2029. This should be 2026, he wrote 29. JAX received a nollie on these charges and prosecution was not pursued. JAX was extradited back to Connecticut on April 29, 2026, and will serve his parole violation notice on April 29, 2026, and the signed notice of parole violation, parole rise, and remand was scanned into case notes on May 4, 2026.
Thank you. On council to confirm you and your client did receive the notice of parole violation, the parole violation report, and all the other documents identified for today.
Yes, I did.
All right, and I did receive 3 exhibits from the defense. I have exhibit 1, the letter dated 4/16/26 from Melissa Flood at Franklin County Jail. Exhibit 2, the email dated 5/21/26 from Melissa Flood, again from Franklin County Jail. And exhibit 3, the list of parole accomplishments and future plans for parole reinstatement. Council, do you need time to submit any other document?
I do not, no.
All right, and I do want to note on the record that since receiving the exhibits from the defense, we have adjusted Mr. Jock's special parole end date to give, since he was incarcerated during that time period. So as of today, his special parole end date is June 17th, 2026. Since he was in custody during that period of time and not in the community. So at this time, it is the state's opportunity to call any witnesses, present evidence, and speak to any of the evidence submitted. So Officer Montoya, any comments at this point towards the
Yes.
detective?
A few things. On the RT screens, it still shows his end of sentence as August 11, 2026. Just wanted to say that.
It does. That's correct.
Number 2, the list of exhibits was received very late. This document was submitted to me on Friday at 2:44 p.m. This hearing is happening on Monday morning. I was given less than 2 hours to review this document. I just want to put that on record.
I'm
These
sorry, which
documents,
document was that? Was that the?
the list of exhibits, and accomplishments, parole
Okay.
accomplishments and future plans for parole. Not only was this document submitted very late, Friday at 2:44, I already found a couple inconsistencies with it, which I'll discuss later. Okay, so let's just go over Mr. Jack's case. He was released to supervision on May 20, 2025 to Roger Sherman Halfway House under Officer Benak. He was transferred to me on 10/2/2025. He was arrested on February 13, 2026 by Pennsylvania State Troopers. He had about 4 months of supervision. During those 4 months of supervision, he did okay. He appeared to be working. He gave me one pay stub on 10/3/2025, just one pay stub. I completed a couple of home visits. His house was nice and clean and organized. And like I said, he appears to be in compliance. I had what I will say, no concerns. On February 9, he asked to go to Florida to celebrate his son's birthday. And he just sent me like a casual text message. I'm gonna go to Florida. I'm driving Thursday. I'll come back Sunday. I wanna go celebrate my son's birthday. And I was not necessarily against him going to Florida because like I said, he is in good standing. I had, we just needed to follow proper procedure, which I need to know where he's staying, when he's leaving, when he's coming back, the name of the person, where he's staying at, the phone number, the address, the vehicle that he's driving, or if he's flying. Like I said, I had no issues with him going to Florida because he was in compliance, or he appears to be at that moment. So I replied to him, you just can go like this. Just I explained to him the procedure, give me a call or text me all the information you need for your pass. He goes, okay, not a problem. Then on 2/12, he sends screenshots of someone in Florida threatening him, saying things like, if you come down here, like alluding to a physical altercation, violence. I guess this person is related to Jack's prior partner and lives with the son that Jax wants to visit. So and they were like really violent in nature, these text messages. So I replied to him. He says, someone sent screenshots and he showed me. I said, you can go to Florida anymore. However, if your son is in danger, we can definitely advise you on how to file for custody from here. I wanted him to follow the proper procedure, to call the authorities. I was willing to make all these calls for him because he kept alluding that his son is in danger, that he had to go down there. And I was like, I'm worried about your freedom. I worry about your compliance with parole right now, in light of these text messages that you sent that are very, violent in nature. I cannot give you permission to go to Florida. With that being said, I do want to help you come in, We'll call Florida, we'll make a report, whatever we need to. And he sends a text message back saying, why does he get to have permission to see my son? He has a relation to my son. I had not seen my son since 2019. And then he goes, I finally got a text message on Facebook. He goes, I was able to get on FaceTime with my son and my son is safe. I'm okay now. Because I've said, if your son is in danger, you need to come in here right away and we need to call Florida authorities. But then he sends this text message on February 12th saying that, oh no, don't worry about it. My son is fine. It's okay. I don't have to go to Florida. It's okay. And then the following call that I get is from the Pennsylvania State Troopers telling me that he was arrested on February 13th. As you can see from his prior parole violations, this is his fourth parole revocation. The problem with Jax is that he does have periods of compliance in which he does follow the rules and does everything he needs to do. But then he also has very poor impulse control. So when he decides to do something against the advice of everyone around him, when he gets an idea in his head, he's just gonna go ahead and do it. Regardless of consequences, regardless of, obligations that he has to the state, to himself, to the family, he just takes off. So that is the concern. We've been at this since 2018, him back and forth. And during those times that he's been out, he's actually being compliant. So I just want to say that when he's out, he does have periods of supervision that he is compliant and follows the rules. But then he gets an idea, he runs with it, he violates his parole supervision. So that is the concern. I understand it's very small amount of time between now and June 17, but due to the fact that he didn't get to tie up his ends in Florida, my concern is that he gets released on parole, he just takes off to Florida, meaning that he only has a few weeks left on supervision anyway, he will have nothing to lose. That's why I'm asking for a revocation until his end of sentence. When he does decide to go to Florida, it's just on him. We will have nothing to do with it. The other thing I wanted to add was that on this list of parole.
Officer Montoya, we're just focused on the charges
that's
right
fine.
now. Yeah, we'll get to the
Okay,
second.
so that's it.
If we get to the second part, then we'll move forward with that. But as of
Okay.
right now, just for the charges. Thank you. I appreciate your testimony. Counsel?
Thank you. I think with regard to the first charge, the absconder charge, I do think the evidence that we submitted, and that evidence was submitted earlier than Friday, that was submitted about a week ago, I believe. It makes it pretty clear that Mr. Jacques did not abscond from parole. He was continuously incarcerated from February 13th until he was extradited back to Connecticut on April 29th. I'm not sure what happened and why parole thought he was released on the 18th. However, we did provide a letter and an email from the jail, and our investigators spoke to a director of the jail personally over the phone to confirm this information. So I do think there may have been some mistaken information here, and there should be no finding with regard to the absconder charge. With regard to charge 2, obedience to the law, I would just know that some of these offenses do appear to be traffic offenses punishable only by a fine, which would not constitute a crime. With regard to the marijuana charge, as well as the charge 3 in the PBR, the drug charge, I just like to say, Mr. Jacques, did you have a valid medical marijuana card on February 13th, 2026?
Yes,
And how long have you had a medical marijuana card for?
since I believe April, originally since 2017, but this card I renewed April of 2025.
All right, thank you. So he did have a valid medical marijuana card. There was no other controlled substances or narcotics found in his possession other than that marijuana. And then if there is a finding on any of these charges, I would like to be heard further with regard to the sanction. Thank you.
Thank you. Anything further, Officer Montoya, towards the charges only at this time?
In regards to the marijuana, I believe marijuana is not legal in Pennsylvania. That's why those charges were brought in. In regards to the absconder, we received documentation from the jail, like his reporting instructions, And the way it was sent to us and it was communicated to us, it appears as if he had been released. So I guess that's where the miscommunication may be. It does appear like what the lawyer said, he had been sitting in jail all along. So I do understand in regards of the absconder, it appears he had not absconded. He was just in custody. So I do agree with that. But he did leave the state of Connecticut without permission after having spoken to me and giving very clear instructions not to leave after being told that I'm gonna help him pursue. If we were able to open process, and I know there was a court process that he was gonna stay at a hotel in Florida and he was gonna be able to fight for custody of his child back, I would have absolutely supported that. But he just went on his own on a vehicle that was unregistered, that was not insured, that the plate was covered. He just did not follow instructions because, again, he has very poor impulse control, very poor.
Thank you. Council, anything?
No, nothing further.
Okay. So then I am gonna announce my findings, Mr. Jack.
I wanted to say, before you announce your findings, hold on one second. On this list of things, he doesn't have a sponsor. He's been evicted. He was evicted on May 3rd. He doesn't have an apartment to go back to. So I don't understand why this was written on Friday, May 29, when he has been evicted for months and actually is all other people living in that apartment.
I think we did indicate if that wasn't possible, he would be seeking a halfway house as backup plan.
Yeah, but like he was put on record that that he wanted to go live at his apartment. This apartment hasn't been in his name since beginning of March. He didn't have a place to go back to.
So we're not there yet, Mr. Jacks. I'm gonna announce my findings and then we're gonna see what needs to take place, okay? So on charge number 1, the condition of absconder, I'm making a no finding. Based on the exhibits presented by the defense, Mr. Jacks was in custody in Pennsylvania during that time period. So it does not meet the elements of the offense. On charge number 2, I have separated each part associated with the offense as charged. I'm making a partial finding. So I'm making a no finding for the registration requirement. The non-PA expired or unregistered. Hold on. Registration required, PA registration expired more than 60 days, non-PA expired or registration 1 count, the obscure license plate, the obedience to the traffic control device, driving at a safe speed, maximum speed limits, freeway and careless driving, the general rule 1 count, as they are all considered violations, not crimes. I'm going to make a finding for the charge of the fleeing or attempt to elude police officers, marijuana, small amount, personal use, and possession of the paraphernalia, because even though they were not in court, Mr. Jack's criminal behavior on that day, his actions that day meet the elements of the offenses. Therefore, the additional evidence in support of those charges are states exhibits B, C, E, and F. I've also separated charge number 3, the condition of drugs, into 2 separate parts, each the first part concerning the marijuana and the second part concerning the scale. I'm going to make a partial finding on number 3 as well. So no finding is going to be made for the part identified by the possession of marijuana, as evidence doesn't meet the elements of the charge. I'm also going to, and then I am going to make a finding regarding the part about the scale, that you did violate the condition of drugs based on the evidence presented in states exhibits B, C, and E. And lastly, on charge number 4, Mr. Jacks, I am finding you violated the condition of travel based on the evidence presented in states exhibits B, C, and F. So that does conclude the fact-finding portion of this hearing. Before I make my recommendation, the state will have an opportunity to speak to your background and history. Once state is concluded, you will have the same opportunity. The purpose of this part of the revocation hearing is to help determine what I recommend. So Officer Montoya, anything additional? We will let Mr. Jacks talk about the apartment, but council did note that he is amenable to half a house. So anything additional at this time, Officer Montoya?
No, again, I just wanted again emphasize his core. This is like his core revocation, and again, I'm not going by how he behaved while he was out. I'm going by when he gets an idea in his head, he just runs with it, and this is why we're going on like I believe a 5th revocation. So let's just finish this sentence. Let's just do a full revocation right now since it's June 17th, and then he can go on and do what he needs to. Thank you.
Thank you. And council?
Thank you. I just wanted to clarify that. I know it was stated he was released in October of 2025. Looking at the movement sheet though, it looks like he was re-released in December of 2024. And then he was sent to the Fellowship House. And then in May of 2025, he was sent to the Roger Sherman House. And then I think he was referred out of the halfway house in October of 2025. So it does appear to me that he's been released for a lot more than 4 months. It looks like he's been released since December of 2024, unless I'm misreading that movement sheet, but it looks like it's been longer than 5 months of supervision.
I'm only counting the time that he was with me, which is 4 months. I'm not counting the halfway house time because he was not supervised by me at that time.
Okay, but he was released and under special parole supervision for that period of time. So he has been under supervision for approximately 16 months now at the time of his remand. As indicated, there were no misconducts listed at all with regard to his time on supervision. So the PBR recommendation, it does describe Mr. Jack as unmanageable on parole supervision, and he has no desire to comply with parole supervision. I disagree with that assessment. I think if he's been under supervision for 16 months with no misconducts, that doesn't sound like somebody who's unmanageable and unwilling to work with parole. He completed the 2 halfway house programs successfully. He transitioned to his own apartment in Waterbury. There was no evidence of any kind of positive drug screens during that supervision. He complied with all the treatment programs apparently mandated by parole. There's no indication in the report anywhere that he was non-compliant with any of the treatment that he was ordered to do. As I indicated, I know there was some marijuana found in his possession, but he did have a valid medical marijuana card at the time. With regard to the apartment's not an option. We understand that. Then he would ask to be released to a halfway house to finish up his parole. So he was working. He has businesses that he's looking to continue. He started 2 businesses of his own, but he's looking to continue working when he's released. He was also working at MLM Home Improvement. He got those jobs back when he was in a halfway house in December of 2024. He does have family in Connecticut, including his parents who reside in Colchester. He does have 3 children, including that one who he did have some concerns about, who is currently in Florida. His other children are much closer. So I understand he has several prior parole violations, but I would ask him to be released the next available date here. I'm glad that we managed to address the issue with the absconder warrant that was, causing Mr. Jack a lot of stress. Given that that's been corrected here, I do think he has demonstrated ability to work with parole over 16 months of supervision. I know he's almost done, but at this time, I'd ask him to be released the next available date. Thank you.
Thank you.
I would like to reply, please.
Yeah.
He does do well at a halfway house setting because that's what we call intensive supervision. As long as he has someone 24/7 looking after him, making sure he's signing out, signing in, calling the employer, making sure he's doing what he needs to do. Yes, I will agree that he did well during the time at the halfway house. The problem becomes when he hits the streets. He is unmanageable in the streets because he does not communicate with his officer when he's running into trouble. The point taken that when he started having issues paying his rent, I went to his house several times and I inquired on multiple occasions, how is he able to afford such a nice place? And if he ever ran into trouble, to please let us know. I wanted to make sure because I was very proud of him because he was doing very well. He had this job, he had this beautiful apartment. However, I was concerned as to how he was going to be able to maintain because I didn't see the organization. I didn't see that he was focused in being parole compliant. Every time I call him at 3 o'clock in the morning, partying at a club with his friends. I had to call him in. I talked to him. I had to tell him, like, what are you doing? Trying to bring him back. So yeah, he does good in an intensive setting in which he has people looking after him all the time. Out on parole on his own, I stand by my statement that he's not manageable, and the evidence is his prior revocations. Every single time he's been when he's out in the community. Thank you.
Thank you, Officer Montoya.
I would just briefly respond. If he does well in a halfway house setting, that's what we're requesting. We're requesting a halfway house setting for the remainder of the supervision here. Mr. Jacques, is there anything you'd like to add before we conclude?
Only thing I want to add is this. Listen, I just really want to thank you, Mrs. Pio Montoya, for everything that you've done because I really appreciate all your work. I really do. And I don't even care about the report. You gotta do your job, you gotta do your job. And you've always had my best interest in mind. I really just appreciate you. So thank you.
Thank you for that, and I'm just so sad that you didn't speak to me, and that I just wish you had like come to see me the next day. I would have come, I would have helped you. You know, I always answer your phone, your text messages. I was always in communication. I tried to accommodate you as much as you could. I cannot come to see you because I have my job. I went to see you at your house. So you know, Jax, you just got think before you act. That's all I ask.
And I can also, if I'm released in a halfway house or whatever happens, I can definitely assure you that I'm not going anywhere. I have my plan to set up, to get a new apartment and set up my life and do what I have to do. I'm not running to Florida. I'm in contact with my son. Well, I haven't been for about a week and a half, but other than that, I've been in contact with him. So I'm not overly concerned right now about his well-being. I'm pretty sure he's safe. So I'm not gonna do anything I'm not supposed to do.
Thank you, Mr. Jax.
Ms. Jax. So I have listened to all the testimony and I've also reviewed all the evidence submitted. With that, Mr. Jackson, I am going to recommend your parole be revoked and that you have no new re-parole date, which is an approximate 4-month sanction. I do want to note on the record that we're talking about a 7-day period difference, 6-day, because this is going to go to the board on June 11th. So the board can change that date if they want to do so. They can let you out that day if they want to. However, just remember your special parole ends on June 17th. So it's a 6-day period difference. In the event the board does decide to let you out for that last week, I'm going to recommend the following conditions: no consumption of alcoholic beverages, behavioral management program for domestic violence, no contact with victim ML, a general no contact with RJ and MJ without parole officer's permission, mental health treatment, no driving without parole officer's permission, and we'll do halfway house placement. So Mr. Dox, like I said, this is going to go to the board on June 11th. The board can do just those two things. They can adopt it and you'll walk out the door on June 17th, or they can lower it to any date they want to between June 11th and the 17th, okay?
Okay.
All right, any questions at this time?
Thank you. Good luck,
Thank
Jax.
you. Thank you.
This concludes the revocation hearing for Mr. Dox, inmate number 3145. Good luck to you, Mr. Dox. Listen to what
Thank you.
Officer Montoya said. She only has your best interest, it sounds like. Think before you act. Yeah, she seems like she really did. All right, good luck to you.
Thank you.
Hi, Jax.
Yeah.
And thank you, Officer Madden. Yeah.
Hello, Brooklyn. We just need you to unmute.
Did I get it?
Yes, we can hear you.
Okay, cool. Sure, we got the right guy up here.
Good morning. Is this Mr. Jackson?
Yes, good morning.
All right, we're gonna get started, okay?
Yes.
All right, so good morning. I'm Parole Officer Trisella, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Herbert Jackson, inmate number 246829. Today is Monday, June 1st, 2026, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office in Brooklyn Correctional Institution. Can you please state your full name and DOC inmate number for the record?
Herbert Lamont Jackson, 246-829.
So this is a public hearing and public access to this hearing is available via video live stream. Present this morning is your attorney. Can you please identify yourself for the record?
Sure. Attorney Alfonso Sirico from the Parole Revocation Unit on behalf of Mr. Jackson.
Thank you. So this is a revocation hearing to determine whether you have violated the conditions of your release. I'll review and make findings of facts as to each of the charges against you. The state, not you, has a responsibility to prove the allegations by a preponderance of evidence, and that is the better or weightier evidence must establish that more probably than not the allegation is true. If I do not find that there is preponderance of evidence to support a violation of one or more of the conditions of your parole, I'll reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I'll consider whether or not your parole should be revoked. And if I recommend revocation, I'll make a recommendation as to an appropriate sanction. A recommendation will then be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So Mr. Jackson, can you please raise your right hand? Do you solemnly swear, solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury?
Yes, I do.
Thank you. We're going to go over the procedure for today's hearing. So first, I'm going to read you your rights. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. I'll then review and identify the exhibits that have been filed for the record. The state is not present at today's proceedings. However, you will have an opportunity to present any relevant testimony and any relevant documents. After considering all the evidence presented, I will announce my findings. And if I find that you have violated one or more of the conditions of your parole, you will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No.
All right, so you do have important rights. We're going to review them now. You're there to be represented by an attorney, and counsel is here present for you. You also have the right to receive the written notice of charges of violation. Did you receive that written notice?
Yes.
Perfect. You have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes.
Now review the charges that the state, your parole officer, is bringing against you, and the information underlying each charge. So on charge number 1, the condition of obedience to the law, the charging officer reported that on March 18, 2026, at approximately 8:20 p.m., the New Haven Police Department was dispatched to 113 Frederick Street, apartment 1R, your approved parole residence. Is this officer? I'm sorry, I just got an email from Officer Massolero to be in attendance for today's hearing
How was that email sent?
right now. No. I'm gonna take a 5-second recess, because if he wants to be here, I think the state should be here. Sorry, counsel. 1 second, Mr. Jackson. I'm just gonna see if we can get your officer to log in, okay?
Okay.
Yo, Masalero, are you able to turn your camera on?
Yeah, just give me 1 second. There I am. Hold on. Morning.
Good morning. So we did get started already. I'm just gonna have
Sorry
you
about that.
state, that's okay. State your name on the record for us, and then I'm gonna swear you in.
Sure. My name is Nick Masalero. I'm a parole officer in New Haven.
Thank you. And can you raise your right hand, please? Do you solemnly swear, solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury?
I do.
Thank you. So we are at the part, Officer say your name wrong, Massolero, where you're going to review the charges for us. So can you please review them for us, starting with number 1, obedience to the law?
I'm sorry, I was not prepared, guys. It's been a crazy time around here. I'm gonna get that case out. I thought the case was tomorrow, so I apologize. And also, this is my first one that I've done, which is kind of crazy. Give me a second.
Yeah, I can I can review it for you today if you want, just so you got it? Okay,
I did.
yeah.
Oh, okay. Right. So I will review. So the charges, one is obedience to the law. On March 18th, 2026 at approximately 8:20 p.m., the New Haven Police Department was dispatched to 113 Frederick Street, apartment 1R, your approved parole residence. Upon arrival, the assigned New Haven police officers made contact with you and your daughter, Tatiana Saunders. The New Haven Police Department officer inquired about a report of possible assault. You and your daughter denied any incident occurred and denied contacting the New Haven Police Department. The assigned officer made contact with the complainant, Tyrese Denny, who reported that he was involved in a verbal and physical altercation with you in which you assaulted him by punching him in the face 4 to 5 times, which caused redness and welts on the complainant's face. Due to the circumstances of the incident, you were taken into custody and were transported to the New Haven Police Department Detention Center. Subsequently, you were charged with assault third, Connecticut General Statute 53A 61-61, breach of peace second, Connecticut General Statute 53A-181. You are in violation of your parole condition section 2, obey all laws, obedience to the law, the criminal violation. As to charge 2, drugs, on or about 11/21/25, you used cocaine and rendered a positive drug screen on 11/21/25 at the New Haven Parole District Office. On or about 3/4/26, you used cocaine and rendered a positive drug screen on 3/4/26 at the New Haven Parole District. Those are the 2 charges.
Thank you. And you've also submitted evidence in support of the case. Can you please identify the evidence for us?
Sure. So the evidence in the case is, sorry. The incident investigation report from the New Haven Police Department.
So just, I know you mentioned first, so we just go down the list. So Exhibit A, the signed statement of understanding and agreements.
Oh, okay. I'm sorry.
That's okay.
All right. So the evidence is his parole conditions that he signed on 6/1/2020.
Yeah.
We have the remand to actual custody order, which was submitted, date of issuance was 3/19/26. His parole violation report, which he signed on 3/24/26. His notice of parolee rights, which he signed on 3/4/26 as well. Then he has the parole violation report. Then we have the incident investigation internal copy report from the New Haven Police Department. The report on the assault. And then we have a misconduct that was issued to him on the misconduct date was 11/21/25 for
You have
positive
them
drug.
lumped, yeah, you have them lumped together, right? So they're all under Exhibit F, the misconduct, voluntary admission, and lab results.
Yes, ma'am.
Perfect. All right. So, and then you did submit an addendum to the parole violation report. Do you have that in front of you? Otherwise, I do. I can review it for us.
I do not have that in front of me.
Okay, so that was submitted on May 7th, and it states that on May 6th that Mr. Jackson was seen in Superior Court for those charges of breach of peace and assault third, and that on that date, the case was disposed of, and they were both nollied. So
Yes.
counsel, to confirm, you did receive the notice of parole violation, the parole violation report, and all the other documents identified for today?
I did.
All right, and I did receive one exhibit from the defense. I have Exhibit 1, the list of parole accomplishments and future plans for parole reinstatement. Counsel, do you need time to submit any other documents?
No.
So at this time, it is the state's opportunity to call any witnesses and present evidence and speak to any of the evidence submitted. So Officer Mussolero, do you have any statements right now just towards the charges?
No, I don't. Nothing in particular. Mr. Jackson, I've had his case since December, and the criminal charges are the criminal charges if they were disposed of in court. I respectfully accept their decision. However, on the drug charges, Mr. Jackson has struggled with his substance use, and I think it's something that should be addressed. Obviously, he claims he wants to address it, and he claims he does, but it has been an issue since I've got his case in December. So, moving forward on whatever the board's decision is, I would recommend that he continues with substance abuse treatment to avoid any future issues while he's on parole.
Thank you.
You're welcome.
And counsel?
Parole Officer Master, you indicated you've been supervising Mr. Jackson since December of 2025 we're referring to?
Yes, sir.
Okay, so you haven't obviously been supervising him since he's been out on parole from June of 2020, correct?
I've transferred from the Norwich district to New Haven. My transfer was in December. I was a SMU Special Management Unit officer in Norwich that ran the January Center for High-Risk Sex Offenders. I did have Mr. Jackson there for a period of time before he transferred down to New Haven. So that I've been reassigned his case because now I'm in New Haven. Yes.
And I don't have anything else to add. I do agree with P.O. Mastalero. I do have the same information. Both charges were nollied in court on May 6th in New Haven Court. So I don't have anything else to add regarding the first part of the hearing. I do want to be heard about my client's background at the appropriate time.
Okay, thank you. I'll just take a sec, that's my findings. So on charge number 1, Mr. Jackson, although the court did not lay that charge, it doesn't negate that the behavior did occur. So I am going to make a finding based on the evidence in states exhibits A, D, and E. I've identified charge number 2 as 2 separate parts, each part associated with a date as charged, and I'm making a partial finding. So I'm making a finding that you violated the condition of drugs for the date of 3/4/2026 based on the evidence presented in states exhibits A and F. And I'm making a no finding for the date of 11/21/25 as the state failed to submit sufficient evidence in support of the charge. Therefore, they did not meet the elements of the charge. So that does conclude the fact-finding portion of this hearing. Before I make my recommendation, the state will have an opportunity to speak to your background and history. After the state is finished, you'll have the same opportunity. The purpose of this part of the revocation hearing is to help determine what outcome I recommend. So, Officer Mastalero, do you have any statements towards Mr. Jackson's background and history?
Not at this time. Again, like I said, I think his issues with substance use is an issue that he needs to address. And he's had opportunities to do that, and I think if given the chance again, he will begin to do it. Hopefully, he will improve his standing on parole.
Thank you. And counsel?
Yes, on behalf of Mr. Jackson, my client has been out since June of 2020. To my understanding, this is his first parole violation, if my math is correct. He's been out for a while. He's 50 years old. He does have two children. Upon his previous release, he did successfully complete the Connection residential program in Uncasville. He did have the counselor, Ms. Daniels, assigned to him, and he was sponsored by his mother, Ms. Jackson. And he then self-sponsored on Frederick Street in New Haven. He did report to us. He did graduate from Hill House High School in New Haven. And he did report to us, he did obtain his CDL license in 1995 and began driving school buses as a career. As far as employment, he did report to us September 2020. We're doing construction full-time with his brother for Jason's Constructions out of North Haven for about 2 years. He had a full-time job at Popeye's Kitchen in Orange, full-time cashier at Alltown Gas Station in Madison. And then he did full-time home health care through a company called GT Independence. As far as his treatment while he's been out in the community, he did report to us, he did successfully complete the CTPS program, and my social worker did receive documentation that he did attend consistently and he engaged in treatment sessions, did participate in Midwestern Connecticut Council on Alcoholism MCCA in New Haven, and he did some relapse prevention group IOP at before entering the App Foundation, and he did successfully complete, looks like June of 2022 to September 2022, did successfully complete relapse prevention group after attending 19 sessions. And then back in December 2022, he did some more relapse prevention group. I don't dispute what P.O. Mastalero is saying. My client does understand substance abuse is an issue and he is willing to do treatment for that. Like I said, he was out in the community for approximately 6 years, so he is able to stay on track. he is able to return as far as housing to his independent housing. Apparently his mother, sister, and family have been keeping up with the rent with the understanding that that all has to be verified by his field parole officer. And we don't have an issue with that. He did report to us, he can return to the GT Independence, for healthcare, for his job, and he's amenable to all treatment recommendation. He has successfully completed a treatment in the past. And he does wonder, as far as community service, he does volunteer, at a, local soup kitchen to give back to the community, and he just want to return back to his church. Mr. Jackson, anything I said that was incorrect or anything you want to add about your background, now's your opportunity. Nothing to do with the charges or the positive drug test. That's the first part of the hearing. That's off the table. Anything about your background or what your goals are when you get out, anything I missed, now's your opportunity to add.
No, that was all correct. I just wanted to say when I had the opportunity 6 years ago to come out, I made a promise that I would be a productive member in society. And I believe that I've done that, and I want to continue to do that and do some meaningful work. And first, that starts off with my relationship with God and spending time with I love spending time with my mother and taking care of her and giving back to the community. And if you don't mind, I just would like to add on to that. Although we got past that, Mr. Masalerno, he's right in that sense. I do want to get myself together. I definitely want to get myself together, and I know that I can do that. I was struggling when a few family members had passed on me, and I just didn't know how to handle it. So my brother died from cancer, and my dad passed away, and I was dealing with some issues I had no idea how to deal with. So I was recommending for myself that I go see a psychiatrist and speak to a therapist. And I went that morning to speak with a psychiatrist, and she recommended that I do a trauma group. And so I spent about 3.5 hours with her the night before I got arrested in orientation, and I was just set up to start a trauma group. And then I spoke with my therapist for about an hour with a good session, and then I was arrested. So I do intend on making those things happen to improve myself.
Thank you, Mr.
Thank you for your
Jackson.
comments.
I'll just take a moment and then I'll announce my recommendation. Is there anything additional from either side?
I don't have anything else to add.
Nothing for me. Yeah.
Mr. Jackson, so I've listened to all the testimony today and I've reviewed all the documents submitted. Based on that, I'm gonna recommend that your parole be revoked and that you serve an approximate 3-month period of confinement as a sanction, and that's with the re-parole date of June 18th, 2026. I'm gonna recommend the following conditions: no contact with victim BCJS, MB, and MR, a general no contact with TD, problem sexual behavior treatment, and Officer Masalero, should I do a halfway house stipulation, or do you think he can go back to his apartment?
I mean, if you could place that on there just in case I can't get in touch with his daughter or his mother, and if somehow the apartment fell through, just so I have that on there just in case I have to release him to a halfway house, please.
Okay, so I'll do halfway house placement stipulation just as a backup plan. So what happens next, Mr. Jackson, is that my recommendation is going to go to the board on June 11th. On that day, the board can do 3 things. They can lessen the recommendation, so any date between the 11th and the 18th. They can adopt the recommendation, and then if for any reason they would want to see a longer period of confinement as a sanction, they'll ask you to come back for another hearing to address their questions and concerns before anything longer is imposed. Right? Do you have any questions right now, Mr. Jackson?
No.
All right, can we just clarify, it's discretionary parole, correct, is what I have? Sentence. That's
I
what
think
I
it is discretionary.
just wanted to clarify with him on our topic.
Yep,
Last time,
discretionary.
correct?
Yep.
All right, so Mr. Jackson, and the reason why I'm bringing this up, it's a little different than special parole. If the Board of Pardons and Parole adopts her recommendation on June 11th for you to be released on June 18th, because you're on discretionary parole, it's on or after date. Unlike special parole, they have to release you the date given discretionary parole carries a different status, okay? So if you don't get out till the 19th or 20th, it's not because they're illegally holding you. It's a little different when you're on discretionary parole. It appears your parole officer is on top of things, so hopefully we can have everything lined up for you, for when, if they have to, as she said, though, they still have to adopt the recommendation on the 11th, and you and I will get something in writing. If they adopt it, then you'll get out June 18th or shortly thereafter. Do you understand that?
Yes.
Okay.
All right, well, thank you, everybody. This does conclude the.
Thank you, Fiona.
Jackson,
Thank you, sir.
460. Good luck to you, Mr.
Good luck,
Jackson.
Mr. Jackson.
Thank you.
Thank you. Thank you very much.
Jackson, have your mom call me or your sister, okay?
Okay, thank you.
Thank you, guys.
Thank you.
Bye-bye.
Oh, hi, good morning. I left. Hello. Uh, Mr. Krajewski? Is he coming down? Oh, I can't hear you. Kristen, are you there? Oh, you're muted. There we go.
He'll be done
Yeah.
shortly, okay?
Okay, great. Thank you.
You're welcome.
I didn't want to. Zero at that point. Where were you? There's more circumstances occurred after you talked to me. With all the information out there hand at that time. So again, if that's what you want to be the guy that breaks the shit and everything, guess what? You gotta do some shit. You're telling me. To get in the club, yeah. This status. How you handle this status is gonna help you determine whether or not you're in that club. You want to go talk to players in the golf club? Oh, I don't know who rather you got. Remember, whatever you decide to do it, you can take me, I'm not even gonna fucking do it. And good decision, they're not your attorney, they're just trying to make their, as a business, they were like, violate. Like, I was going, yes, yeah.
Polish, yes. Oh. Big laptop and dump. Yep. Hello.
Mr. Krajewski, how are you?
I'm okay. How are you?
Good. We're gonna get started, okay?
Okay.
All right. So good morning. I'm Parole Officer Trisell, and I'm the hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Michael Krajewski, inmate number 187569. Today is Monday, June 1st, 2026, and this hearing is being conducted via video at the Board of Pardons and Parole Central Office and Corrigan Correctional Center. Can you please say your full name and DOC inmate number for the record?
Michael Douglas Krajewski, 187569.
Thank you. So this is a public hearing, and public access to this hearing is available via video live stream. So this is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of facts as to each of the charges against you. The state, not you, has a responsibility to prove the allegations by preponderance of evidence, and that is the better weight of your evidence must establish that more probably than not the allegation is true. If I do not find that there is preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I'll consider whether or not your parole should be revoked, and if I recommend revocation, I will make a recommendation as to an appropriate sanction. A recommendation will then be given to the panel for a final decision, and if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So, Mr. Krajewski, can you please raise your right hand? You solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury.
I do.
Perfect. We're going to go over the procedure for today. So first I'm going to read you your rights. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. We'll then review and identify the exhibits that have been filed for the record. The state is not present at today's proceedings. However, you will have an opportunity to present any relevant testimony and any relevant documents. After considering all the evidence presented, I will announce my findings. And if I find that you have violated one or more of the conditions of parole, you'll have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No, I don't.
Okay, so you do have important rights, and we're going to review them now. The first is you have the right to be represented by an attorney. You may hire your own attorney, and if you cannot afford an attorney, you may qualify for an appointed attorney to represent you. So, Mr. Krajewski, were you informed you could have an attorney for today's hearing?
I was.
Do you intend to seek counsel?
No, I don't need. I'm
So
good.
you're willing to move forward without legal representation today?
Yes,
Okay. You also have the right to receive the written notice of charges of violation. Did you receive that written notice?
I did.
And you were able to review that notice?
I did.
Perfect. You have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
I do. I'm ready to go forward.
So before we start, I do just want to note on the record that an addendum was submitted by Parole and Community Services on May 6th that states that they withdrew their pending Massachusetts charge against you. Therefore, that part of the charge is not going to be taken into consideration at today's hearing. So I just want to
Thank you.
cross that off so I don't review it. So I'm going to start with charge number 1, the condition of GPS. The charging officer reported that on the following dates, your GPS monitor device was shut down due to not charging it. That's January 14, 2026, January 18, 26, February 17, 26, February 26, 26, March 6, 26, March 14, 26, March 20th, 26, and March 23rd, 26. On charge number 2, the condition of obedience to the law, the charging officer reported that on 9/3/25, you were operating a motor vehicle in the town of Plainfield, Connecticut. Plainfield, Connecticut. You were driving recklessly by screeching your tires and speeding erratically when you were stopped by Plainfield Police Department. You were arrested for operating a motor vehicle without insurance, operating with a suspended license, and reckless driving. Based on your actions, you are in violation of your special parole conditions. On charge number 3, the condition of travel, the charging officer reported that on 9/28/25, you were arrested in the state of Massachusetts and you were not given permission to be out of the state of Connecticut. On 4/25/24, you were in the state of Massachusetts at the victim's residence and you were not given permission to travel to the state of Massachusetts. And lastly, on charge number 4, the condition of no driving, the charging officer reported that on 3/27/26 at 2:24 p.m., you were observed operating a motor vehicle in the town of Killingly, Connecticut. You do not have permission to operate a motor vehicle. So the evidence submitted by the state was already identified at the preliminary hearing. That all does remain the same. The state did submit 2 addendums.
Is that one, but I don't mean to interrupt you, but the one that really gets me is the one in Plainfield. The computer clearly states that I never got arrested. My insurance was never relapsed. My license was never suspended, ever. So I don't know what those are coming from. They told my truck for, and I showed the prosecutor my registration and my insurance, and she said, "You're absolutely right." That never was. My license was.
No, thank you, Mr. Pertusi. I just want to let you know that the state did file an addendum. What that means is that they submitted what happened in court to me, and what that reads is that on 4/13, you were in court for the count of reckless driving. You got an unconditional discharge. The operating
Unfortunately, I could have waited a little bit longer because the video I seen, but I wanted to get rid of it. I didn't want it to show up for this hearing, right? Yeah. So to be completely 100 honest with you, I was kind of in a push or a shove. If I waited for this, I probably could have not got this. I would have won that. I would have beat that, but to get it off that, I just said, so it's not on my record to get this cleared up. I pleaded guilty to it because it was supposed to only be $100 fine. That's what the prosecutor told me. It was going to be $100 fine, but my lawyer did tell me that at this point, if I do not go with it at that time, it's going to be on here. It will be still on here as a court case. That's one reason why I just got rid of it that moment. I just wanted to let you know that. I just wanted it off the record. I just want to move forward with it. It's done.
That's what it says. So they disposed of it with the unconditional discharge, and then the operating without insurance and the operating with a suspended license were not prosecuted against you.
Right.
So,
okay.
Yeah, no. So, and then the charge of the larceny, that's still pending in Massachusetts, but they withdrew that, so we don't need to address that.
Because my sister talked to the commissioner right off the rip, and the guy admitted that, this was they ordered the materials August something. I didn't get them until September 14th, and they filed it on August. Before the materials came in, they ordered. These people ordered these materials. So they said they didn't want to do it.
I don't want you to talk about that case because from what my understanding is it's still pending and this is live stream. So it's still open in Massachusetts. Don't talk about it on live stream at this point. The state of Connecticut has withdrawn it. It's not being held against you for this hearing, just those charges that I read. So I just do want to confirm that you have reviewed all of the evidence submitted against you. You're ready to move forward.
Yes, I am.
Okay. And I have not received anything from you at this time. Do you need time to submit anything from me? I feel like you already gave me some testimony that I took notes on.
I'm okay. I'm good. I just want to move forward. I don't,
All right. So I did, this is your time to speak towards the charges, but you do have the right to remain silent if you choose to do so. I did hear you that your license was never suspended. You were never uninsured. You just took the plea to kind of move the parole hearing forward. It sounds like.
100%.
Okay, anything about the no driving or the GPS, but you do have the right.
I'm gonna admit, when I said no driving, I am I don't know if where I live, it's very, very muddy and I wear these muck boots. I'm not trying to make any excuses in no way, but I don't know if that's got an on and on button, but the boots go up to my knees and I don't know, sometimes when I stun my boots, my thumb would hit if it has a power button, I'm not sure. But as far as the GPS not being going off, I don't know too much about that, but I did charge it 2 times a day when I plug it in at night. I wasn't, the vibration a few times it did vibrate a few times, but as far as, maybe of not seeing that red light a couple times, I'm gonna have to say 3 times I did see that, but I don't know if it was careless or maybe me hitting it. It could have been. It could have been. I didn't, to be serious with you, I didn't think it was that, when I plugged it in, when it went down, I didn't think it was off that. I guess when it shuts down, it shuts down. It's a violation. Understandable. I guess it's gonna have to be a little more careful, with that. I mean, a little more careful with it. I didn't, I apologize. I'm gonna have to say that, and as far as the driving goes, I have 1 more year of special parole, and I'm never gonna, from here on out, I give you my word, you ain't gonna see me back here, and I'm not gonna get behind the wheel unless I'm told to, and that's a God's honest truth. That's just the way it has to be. That's
I do appreciate your statements, definitely. Okay, so I'm gonna just announce my findings towards the charges. So on charge number 1, I am gonna find you violated the GPS based on the evidence in States Exhibits A, D, E, and H. At the preliminary hearing, we already addressed the no insurance because that's a violation. It's not a crime. So those were not taken into consideration today. Again, the Massachusetts charge was not taken into consideration today. So what I did take into consideration today was the illegal operation of a motor vehicle. I am going to make a under suspension. I'm making a no finding based on your testimony today and at that hearing that your license was and never was suspended. And then I am going to make a finding that you violated the condition of obedience to the law based on that conviction of the reckless driving when you received the unconditional discharge. In addition to evidence in support of that conviction and charge is States Exhibits A, D, and G. And then on charge number 3, I'm also finding that you violated the condition of travel based on the evidence presented in States Exhibits A, D, F, and M. And charge number 4, I'm finding that you violated the condition of no driving based on your testimony today, as well as States Exhibits A, D, G, and K. So that does conclude the fact-finding portion of this hearing, Mr. Krajewski. Before I make my recommendation, you'll have an opportunity to speak to your background and history. The purpose of this part is to help me with any recommendation that I'm gonna give. So what are your plans for release, like housing, employment, what's gonna go on when you get released?
I'm gonna go home and just do what I'm doing. I'm gonna line up different rides that I have to. I'm not gonna drive if I'm told not to. If I can't drive, I'm not gonna drive. Simple as that. You won't find me back in here for that. I've been on special parole for 8 years. This is my very first time. I have a year left. This is, I feel like that early, I was gonna sign up for the early release parole, but I guess this kind of messed it up.
Yeah, there's probably gonna need a period of compliance. So tell me a little bit more, what's home mean? Do you have a sponsor? Do you need a halfway house?
Oh, no, I got my own house. I'm going home to my Michelle Smith. She's my sponsor and everything. 263 Curry Road, my same address. I'm going home there. Everything, nothing's changed on that.
I just want to make sure I have the information in the system before we,
Yep, 263 Curry Road, Pomfret Center. That's my address. Same address. I'll be going to the same place.
Who lives there with you?
Just Michelle Smith, my fiance.
And then what about employment?
Right now, I'm going to surgery. As soon as I get out, I'm gonna call my doctor. I'm having my left shoulder replacement.
Okay.
I'm having disability right now for that through my, I was supposed to have my surgery got canceled due to this, not having a medical aftercare because of this. So my doctor canceled it due to infections and not healing properly. He told me when it's all over, when I get out, to contact him and he'll do the surgery. So immediately I'm gonna get my doctor's appointment and go to my surgery and get my shoulder fixed. I have a 2-inch rotor cuff tear that cannot be fixed. It's missing.
Okay, so that's pretty intensive surgery.
Oh, yes, it's definitely an intense surgery. Yes, it is. I'm gonna be down for 16 weeks at least.
Okay. And I just want to confirm, Mr. Kajewski, Miss Smith's phone number, it ends in 6408.
Yes, ma'am.
All right, so we covered the driving, the travel. You understand you cannot travel without permission as well. I know you mentioned the driving, you're not going to drive without permission. You do understand that as well?
I 100% not gonna get caught up in that again. I got 1 year left. I will not get caught in that again. I promise you that.
All right, so I'm just going to take a moment, then I'm going to announce my recommendations. Okay, so I appreciate you talking to me. I've listened to your testimony today. I've reviewed all the evidence provided. With that, Mr. Krajewski, I'm going to recommend your parole be revoked and that you serve an approximate 3-month period of confinement as a sanction. That's with the re-parole date of June 30th, 2026. I'm going to recommend the following conditions: no consumption of alcoholic beverages, no contact with victim WR Jr.'s family, no operation of a motor vehicle without parole officer's permission, and I'll do your sponsor information, so we will not do the halfway house. So what happens next, Mr. Krajewski, is that this recommendation is going to go to the board on June 11th. On that date, the board can do 3 things. They can adopt that date, which is June 30th, so about 2 weeks after that is what I'm recommending. They can lessen it if they choose to do so. So they can pick any date between June 11th and June 30th. And then if for any reason they would want to see a period of confinement longer than June 30th, they'll ask you to come back for a 3rd hearing to address their questions and concerns before anything longer is imposed. Okay, so what happens is on June 11th, I'll present it to the board, and then you'll get it in the mail about a week or so after what their final decision is. And if again, like I said, if anything longer than what June 30th is, then you'll be notified because you'll be back for a hearing the next week, okay?
Okay.
All right, so that does conclude today's hearing. Do you have any questions for me?
No.
All right, so this concludes the revocation hearing for Michael Krajewski, inmate number 187569. Good luck to you, Mr. Krajewski.
Thank you. You have a good day.
You too. Take care.
You too.